CIV3701 Stage 2 Litigation Part 1 Applications. Introduction. The application procedure is one of two main ways in which you may approach a court of first instance, as opposed to a court of appeal, for relief. Unlike the action procedure, in which oral evidence is given by witnesses at a trial, applications are decided on the papers placed before the court. All the evidence a party wishes to put forward in support of a claim must be included in his application papers. In practical terms, High Court application papers consists of a notice of motion, that is, a notice that an application is to be made to court, together with an affidavit which is known as a founding affidavit. In certain cases, you will have more than one affidavit, in which case you will have a notice of motion, a founding affidavit, and a number of supporting affidavits. You may also have supporting documentation attached to the affidavits in the form of various annexures to the affidavits. These annexures, together with the details set out in the affidavits, will contain not only a summary of the main facts of the claim being made, that is, the cause of action, but also the evidence which is being put forward in support of the claim. In terms of Rule 55 of the Magistrates' Court's Rules, application proceedings in regional and district magistrates' courts are substantially the same as High Court procedure in terms of Rule 6 of the High Court Rules, although the Magistrates' Courts Act 32 of 1944 and Magistrates' Courts Rules only provide for applications in certain limited circumstances. The application procedure is specifically designed to deal with matters which are capable of being decided by a court on the papers before it, without the need for a full-blown trial. You may think of the application procedure as a special type of legal vehicle, which is designed to bring specific types of matters before the court. We begin this part of the book by considering the general principles applicable to applications. Then we examine on-notice applications. Finally, we discuss Ex-Parte applications. A. General principles. Number 1. Distinguishing characteristics. The normal procedure involved in bringing an application before court entails giving notice to your opponent. These applications are called on-notice applications in this book. Sometimes, however, applications are brought without giving notice to the other side at all. These are called Ex-Parte applications. Ex-Parte applications are often brought on an urgent basis, which may result in non-compliance with certain rules of court. Such applications are known as urgent Ex-Parte applications. Finally, note that certain types of applications are brought to achieve certain objectives during existing application or action proceedings. These are called interlocutory applications. These distinguishing characteristics will be combined in different ways in different applications. Let us examine each of these characteristics, starting with the last. Interlocutory applications. Interlocutory applications do not initiate proceedings, but are incidental to proceedings that are already pending. Let us assume that you are suing by way of action and are busy with the pre-trial procedure. You request the other side to discover, that is, disclose all relevant documents, in terms of High Court Rule 35, Subsection 1, but they fail to deliver their discovery affidavit within the required period of 20 days. In terms of Rule 35, Section 7, you may now make application to court to compel the opposing side to discover. This application will be an interlocutory application because it does not initiate proceedings, but is part of proceedings that are already pending. Since it relates to a matter that is already pending, an interlocutory application will be made under the existing case number. The documents in such applications may be delivered to the service addresses provided for in the main proceedings. Interlocutory applications may be distinguished from normal applications, which are not incidental to other proceedings, but stand on their own as the main legal vehicle for obtaining relief in a particular matter. On notice applications consists of a notice of motion together with supporting affidavits which must be served on the respondent by the sheriff, while ex-parte applications may be brought subject to various requirements in Rule 6 of the High Court Rules and Rule 55 of the Magistrates Court's Rules without giving prior notice to your opponent. Number 1.2. Urgent applications. An urgent application is just like any other application. Because it is urgent, it may not be possible for the applicant to comply strictly with the rules of court relating to service and notice periods. Obviously, the court will not allow the normal rules relating to applications to be disregarded without good reason, and the applicant must always strive to comply with the normal rules as far as possible, taking into account the urgency of the particular situation. The applicant must inform the court fully of the reasons why the application is urgent and why he cannot wait in order to obtain relief by making the application in the normal way. An applicant launching an urgent application may formulate his own time periods for the respondent to file an answering affidavit, which the respondent is obliged to obey until the hearing of the application. At the hearing, the respondent may object to the time periods given by the applicant. It is then for the applicant to convince the court that the matter is so urgent that it justifies those time periods. Depending on the urgency of the matter, a progressive deviation from the rules will be permitted. For example, the urgency of the matter may only be such that it is not possible to comply with the full notice requirement, meaning that the notice period will be shortened somewhat. In more urgent matters, it may not be possible to give notice at all. In other words, there may not be sufficient time to have the application papers served on the respondent. In the most urgent matters, there may not even be enough time to draft the application papers or to have the matter heard within normal court hours. In such cases, the application will have to be made orally to a judge or magistrate after hours and may even have to take place at the judge's home or another venue outside of the court. It is important to remember that an applicant cannot create his own urgency. For example, an applicant cannot intentionally delay taking action until it is nearly too late and then expect you, his lawyer, to wake the judge on duty in the middle of the night for an urgent application. In KwaZulu-Natal, before the High Court Registrar would enroll a matter for hearing on an urgent basis, an advocate or an attorney with a right of appearance in terms of Section 4 of the Right of Appearance in Courts Act 62 of 1995 must attach a certificate of urgency to the papers. A certificate of urgency is a short document in which an advocate certifies that he has carefully considered the merits of the matter and that it appears to be urgent. The wording of the certificate usually reads as follows. I, the undersigned, Jane Tubela, an advocate of the High Court of South Africa, practicing as such at chambers at 6 Durban Club Place, Durban, KwaZulu-Natal, do hereby certify that I have read the notice of motion and affidavit in this matter, and that I am of the view that the matter is of sufficient urgency to justify an urgent hearing and to warrant the rules relating to notice and set down being dispensed with. The signing of a certificate of urgency is not a mere formality, and in some divisions, the signatory of such certificates may be ordered to pay costs de bonus proprius of the matter if the matter is not in fact urgent. Note that urgency may also justify a relaxation of the rules of evidence. For example, in an urgent matter, an applicant may rely on hearsay evidence, provided that the applicant states the source of his information, affirms under oath that he believes the information to be true, and states the full reasons for his belief. The customary phrase used when a deponent is about to make a hearsay statement in these circumstances is that he is informed of and verily believes certain facts on which he relies for relief. Note further that in terms of High Court Rule 6, subsection 12c, a person against whom an order was granted for his absence in an urgent application may, by notice, set down the matter for reconsideration of the order. Urgent applications are frequently brought ex parte. Number 1.3. Ex-Parde Applications versus on-notice applications. In general, if you want to make an application to court that might affect the interests of someone else, you must give notice to that person that you are going to make the application. Obviously, the reason for this is to give that person a chance to put his side of the story before the court. Audi alteram partem. As a result, most applications are brought on notice. In some cases, however, no one else may have an interest in the application, or there may be some compelling reason why it is undesirable or impossible to give notice of the application to the respondent. These applications brought without notice are known as ex-parte applications. The rules of the High Court provide for a short form and long form notice of motion. Form 2 and Form 2 subsection A of the High Court rules, respectively. Whether a long form or a short form notice is to be used depends on whether the application is brought ex parte or on notice. Number 2. Notice of motion, the general principles. When lawyers talk about bringing a notice of motion, they mean that they are making an application to the court. The notice of motion is therefore a notice that a motion, in other words an application, is going to be made to court. The party bringing the application is known as the applicant, and the party against whom the application is brought is known as the respondent. A notice of motion performs the same function for an application that a summons does for an action. That is, it calls upon the respondent to come to court to answer the applicant's claim. In the High Court, the notice of motion contains several items of information. Firstly, the identities and addresses of the applicant and the respondent are set out. Secondly, it gives the respondent certain time limits within which to act. In the notice, the applicant states a date which may not be less than 5 days after service of the notice on the respondent, on or before which the respondent is required to notify the applicant in writing that he intends to oppose the application. Furthermore, it warns the respondent that if he does not give notice of his intention to oppose, the matter will be set down for hearing in a day not less than 10 days after service on the respondent of the notice of motion. Finally, it informs the respondent of the relief or remedy sought by the applicant, that is, the order sought by the applicant. The Magistrates' Court's rules are substantially the same as its High Court equivalent, Rule 6. The notice of motion is supported by written evidence, made under oath or affirmation in the form of affidavits which will now be considered. If a mistake appears in your notice of motion, it may be amended using the procedure set out in High Court Rule 28. The amendment will generally be allowed provided it is bona fide and will not cause an injustice to the other side which cannot be remedied by an appropriate order for costs. Number 3. Affidavits, the general principles. Number 3.1. Form and content of affidavits. In applications procedure, the notice of motion will be supported by the founding affidavit as well as any supporting affidavits that are necessary. An affidavit is a statement made under affirmation or oath, also called a sworn statement, which is signed and affirmed or sworn to by the person making the statement, known as the deponent, before a commissioner of oaths. The oath or affirmation is administered because of the information contained in an affidavit constitutes evidence. In the same way, a witness taking the witness stand in action proceedings has to take the oath or affirmation before giving evidence. A deponent testifying on paper has to take the oath or affirmation to give the written statement the status of testimony. An affidavit should be drafted in the first person. that is, from the deponent's point of view, and while formal and temperate, it should not be burdened with legalese. Once an affidavit is deposed to, a deponent cannot amend it using the rules of court. Rather, he must seek the leave of the court to submit a further affidavit to explain and correct the incorrect statement in the earlier affidavit. As far as the formalities relating to affidavits are concerned, an affidavit will usually start as follows. I, the undersigned, Joseph Ray Soap, identity number 720211510289, state under oath as follows, and then the statement follows. Immediately after this, the following paragraph usually appears. Save as indicated, otherwise the facts deposed to are within my personal knowledge. Okay, the affidavit is divided into numbered paragraphs, each of which containing a separate averment or allegation. Where for some reason it is more convenient to make more than one averment in a paragraph, the paragraph should be divided into numbered subparagraphs. The idea is to make the deponent's allegations easy to follow. The same principles apply to affidavits that are written in response to other affidavits. If, for example, an applicant makes his allegations in separate and numbered paragraphs in his founding affidavit, it is easy for the respondent to respond to each of these allegations in his answering affidavit. That is, by referring to the number of each paragraph in the founding affidavit and briefly stating whether he admits or denies the allegations made. The process of responding to the allegations of the opposing side's affidavit in this manner is known as transversing the other side's affidavit. The statements made in the paragraphs of the affidavit may be supported further by additional documents, that is, for example, invoices or receipts or etc., which are attached as annexures to the affidavit and cross-referenced in the relevant paragraphs of the affidavit. Finally, the affidavit will be signed by the deponent and also by the Commissioner of Oaths after the Commissioner has administered the oath or affirmation to the deponent. The conclusion of the affidavit may look something like this. So then you can just check that example. Okay. Then we continue here by each page of the affidavit. Okay. Each page of the affidavit, as well as any additions or alterations made to the affidavit, must be initialed by the deponent and by the Commissioner of Oaths. Note that the attorney acting for the deponent or any other member of his firm may not act as a Commissioner of Oaths in the deponent's matter. As a general rule, a commissioner who has an interest in a matter may not administer an oath or affirmation for that matter. If the applicant is a natural person, the founding affidavit is usually deposed to by the applicant himself. If supporting affidavits are necessary, they are usually much shorter and confirm what the applicant has said in his affidavit regarding the person making the supporting affidavit. This is to prevent the evidence in the founding affidavit from being dismissed as hearsay. Remember, the formal requirements for documents regarding the form it should take and the typing, binding, and indexing thereof, as set out in High Court Rule 62, apply to all affidavits. Also note that, as the affidavits in the application matter contain all the evidence in the case, the normal rules of evidence apply. Furthermore, any person who knowingly makes a false statement in an affidavit is guilty of an offense. The offense carries the same penalties as that of perjury. Having considered the formalities of the affidavit, let us take a closer look at the contents of the founding affidavit and supporting affidavits. Number 1. Locus standi. The first substantive paragraph of the founding affidavit usually contains the full name and address of the applicant, and the second paragraph contains the same information in respect of the respondent. In addition, it must be clear from the affidavit that the parties have locus standi to bring the application. See Stage 1, Part 1, where locus standi is discussed in detail. Number 2. Legal capacity. The legal capacity of the applicants must also be shown. If a legal guardian is assisting a child, the affidavit should state that the party suing is duly assisted to the extent that it is necessary. Persons suing in a capacity other than personal, such as executors of estates or an agent acting on behalf of a principal, should also indicate that they are acting for and on behalf of another, and in what capacity. Similarly, if the applicant is a legal person, such as a company or a closed corporation, the person deposing to the affidavit, usually the managing director of a company or the managing member of a closed corporation, should allege that the legal action, that is, bringing the application, has been approved by the company or closed corporation. It is always necessary for the directors of a company to obtain a company resolution approving the legal action before suing, and it is good practice to refer to the resolution in affidavits and to attach it as an annexure. When a deponent is a company director or deposing in some other representative capacity in an affidavit, the practice is for the deponent to state that he has been duly authorized to depose to the affidavit. Strictly speaking, the deponent does not need to be authorized to depose to the affidavit, but you will frequently see this statement made in affidavits. So, common is the practice that failure to indicate that the deponent is authorized to depose to the affidavit may result in your opponent taking the point against you if you do not include it. To avoid this, we see no harm in also including a statement that a deponent is duly authorized to depose thereto. Number 3. Jurisdiction. The founding affidavit must contain sufficient facts to establish the court's jurisdiction. For instance, that the respondent lives within the jurisdiction of the court, or that the cause of action has arisen within its jurisdiction. The facts need not be alleged expressly if they emerge from the facts as contained in the founding affidavit. For instance, if it is clear from the citation of the defendant that he resides within the area of jurisdiction of the court, it is not necessary to state specifically that the court has jurisdiction. Number 4. Urgency. If the application is an urgent application, the founding affidavit must set out the grounds of urgency in accordance with Magistrates Court's Rule 55, Subsection 5, or Rule 6, Subsection 12b of the High Court Rules. Number 5. Grounds for relief. The founding and supporting affidavits will set out the grounds upon which the relief is claimed. In other words, sufficient facts must be set out to disclose and prove a cause of action. This comes from the substantive law, for example, elements of a delict. The founding affidavit in an application matter combines both pleadings which set out the cause of action and evidence which prove the cause of action. All the allegations that would be contained in the written pleadings of an action matter, the facta probanda, together with all the facts which would be elicited from the witnesses at the trial of such action, facta probantia, have to be included in written form in the founding affidavit of an application. If the founding and supporting affidavits fail to disclose a cause of action, the respondent is entitled to ask the court to dismiss the application on the basis that it discloses no grounds on which the relief may be granted. In other words, the respondent has no case to meet. Number 3.2. Inadmissible evidence in affidavits. We shall now consider some of the kinds of evidence founding and supporting affidavits may not contain. Number 3.2.1. Hearsay. The affidavits may not, as a general rule, contain hearsay evidence. Where a deponent includes in his affidavit facts of which he does not have first-hand knowledge, this is hearsay, and he must annex to the affidavit a supporting affidavit, here called a verifying affidavit, by someone who does not have first-hand knowledge of the facts. In the case of urgent applications, however, it may be impossible to obtain verifying affidavits in the limited time available. As the situation is urgent and only temporary relief is sought prior to a further hearing when the matter will be finally decided by a court, hearsay evidence will usually be permitted. In such urgent matters, the applicant may not state the hearsay matter as if it were direct evidence, but must indicate to the court that the allegations are hearsay by stating that the deponent is informed of and verily believes the facts upon which he is relying for temporary relief. The applicant must set out the facts on which he bases the grounds for his belief, and how he obtained the information, as the opposing party must be able to check the source of the hearsay information in order to verify its truth. Number 3.2.2 Privileged communications. Privileged communications are privileged from disclosure in all circumstances and are accordingly inadmissible in affidavits as well. They include statements made or written without prejudice. Communications between attorney and client contain certain communications between husband and wife and state privilege. Number 3.2.3 Matter excluded by the rules of court. Number 3.2.3a Scandalous, vexatious, or irrelevant matter. In terms of Magistrates Rule 55, Subsection 9, and High Court Rule 6, Subsection 15, the affidavits may not contain matter that is scandalous, vexatious, or irrelevant. The meaning of each of these terms has been defined as follows. First, a scandalous matter is allegations that may or may not be relevant but are worded in such a way as to be abusive or defamatory. Note that certain evidence, such as an accusation of infidelity in respect of matrimonial proceedings, might be highly defamatory, and yet be acceptable in terms of this rule, because of its relevance. If in these circumstances the allegation is couched in unnecessarily or gratuitously insulting terms, however, it will fall foul of the rule regardless of its relevance. Secondly, vexatious matter is allegations that may or may not be relevant but are worded in such a way as to convey an intention to harass or annoy. And lastly, number 3, irrelevant matter. Allegations that do not apply to the matter in hand and do not contribute to the making of a decision in the matter. This has the effect of burdening the papers by making them unnecessarily prolix, that is, long-winded. Okay, number 3.2.3b, Inadmissible New Matter. The applicant's case stands or falls by the contents of his founding affidavit. New information or issues that have not been included in the founding affidavit may not be raised in a replying affidavit. The purpose of the replying affidavit is to rebut issues raised by the respondent in his answering affidavit, and do not constitute an opportunity to include issues or information that the applicant forgot to include in the founding affidavit. All the facts needed to support a claim for relief must be set out in the founding affidavit, and new issues may only be raised in limited circumstances. Number 3.2.4 Matter excluded by the use of inherent jurisdiction. The matters excluded by the rules of court do not comprise an exhaustive list, and the High Court may use its inherent jurisdiction to exclude other matters in order to grant relief in cases where Rule 6, Subsection 15 is silent. The following are examples. Number 1. Irrelevant attacks on credibility. An attack an attack on the credibility of a person is generally regarded as irrelevant and is in most cases excluded by the law of evidence. For example, to embark on a personal attack on someone's trustworthiness about a matter unrelated to the case is not allowed. Number 2. An argumentative matter. Only the facts of the matter should be stated, and parties should not embark on an argument on paper in relation to the facts or the law. In other words, the affidavit should not contain any legal arguments attempting to convince the court to reach the conclusion that the facts given by the other side are wrong, or that there is no legal basis for the claim or relief. In practice, you may see legal argument or reference to legal authority in affidavits despite strong judicial disapproval of this. Number 3.3. Striking out inadmissible evidence. If the affidavits do contain inadmissible matter, the other party may make an application for the court to strike out the portions of the affidavits being objected to, that is, in order that the objectionable material in the affidavits concerned are considered deleted, rendering them inadmissible as evidence. The court will only grant such an application, however, if it is satisfied that the applicant will be prejudiced in his case if the application to strike out the evidence is not granted. An application to strike out objectionable matter is an example of an interlocutory application, and it is based on an objection to evidence. It is heard when the merits of the matter are argued. This application is heard and the decision whether or not to strike out is taken when all the affidavits have been delivered and are before the court, and the matter has been set down for hearing. This is because an application to strike out a matter from an affidavit is not an objection to a pleading, but an objection to evidence proposed to be tendered to the court hearing the application. B. On notice applications. Number 1. When is it appropriate to bring an on notice application? Generally speaking, when you are seeking a final relief against someone, or when someone's rights or interests will be affected by the order you are seeking, the application should be made on notice to that person. Therefore, other than in those limited cases where it is permissible to bring an application ex parte, you are obliged to bring the application on notice. In all civil courts, the application is brought by notice of motion, supported by affidavits. In terms of Magistrates Courts Rule 55, Subsection 4a, interlocutory applications must be brought on notice, whereas in terms of High Court Rule 6, Subsection 11, High Court interlocutory applications may be brought on notice, supported by affidavits. Remember that with a High Court application on notice, every single person who has a legal interest in the matter must be cited as a respondent. What follows below are the steps in sequence that must be followed in preparing, serving, responding to, and hearing an on notice application. Note that Rule 55 of the Magistrates Courts Rules provides similar detailed procedural guidance to Rule 6 of the High Court Rules. The first step in all courts is to draft the notice of motion. Number 2. Step 1. The applicant's notice of motion. 2.1. High Court Notice of Motion. High Court Rules Form 2, Subsection A sets out the details which must be contained in a notice of motion in an on-notice High Court application. If you look at the bottom of Form 2, Subsection A, you will see that it is addressed to the respondent and the registrar, which means that copies of the application papers have to be served on the respondents as well as the registrar. On the notice of motion, the applicant must state the order that he wishes the court to make. The order prayed must be set out in such a way that the court can make it an order of court without any amendments. The first part of the order requested sets out the main order you want the court to make. For example, you may ask the court for an order prohibiting your neighbor from undermining your property by digging within 10 meters of your common boundary wall. The order should not be ambiguous or open-ended. This is usually followed by a request for costs and finally a prayer asking for further and/or alternative relief. The next portion of Form 2, Subsection A, requires you to state the names of the persons who have deposed to affidavits in support of the notice of motion. Form 2, Subsection A, then goes on to set out an address at which the applicant will accept service of the documents in the matter. The service address must be within 15 kilometers of the office of the registrar. This is very important in practice since it ensures that parties do not have to go running all over the country to serve documents. If you are a Durban attorney who has been asked to act in a matter that is being prepared in the Gauteng local division, Johannesburg, for example, you have to appoint an attorney in Johannesburg who has a service address within 15 kilometers of the Gauteng local division, Johannesburg, to act as your correspondent. That is, the attorney in Johannesburg acts as your agent to receive documents on your behalf. The next part of Form 2, Subsection A, sets out the respondent's options, what he must do if he wants to oppose the application, and what will happen if he does not do so. These options will be examined in detail later. Finally, the notice of motion is signed by the applicant or his duly appointed attorney. Number 2.2. Regional and District Magistrates Courts. Notice of Motion. Magistrates Courts Rules Form 1A of Annexure 1 sets out the details that must be contained in a notice of motion in a regional or district magistrates court matter. In the notice of motion, the applicant must state the order that he wishes the court to make in such a way that the court can make it an order of the court without any amendments. The first part of the order sets out the main order you want the court to make, followed by a request for costs and a prayer asking for further and/or alternative relief. The form also requires you to state the names of the persons who have deposed to affidavits in support of the notice of motion, and to state an address at which the applicant will accept service of documents in the matter. The service address must be within 15 kilometers of the office of the registrar of the regional magistrates court or clerk of the court in the magistrates court. The form then indicates the respondent's options and has to be signed by the applicant or his duly appointed attorney. Number 3. Step 2. The applicant's founding and supporting affidavits. The main evidence in support of the notice of motion will be contained in an affidavit by the applicant called the founding affidavit. If there are other witnesses who support the applicant's version, their affidavits are called supporting affidavits. Sometimes a witness may make an affidavit merely agreeing with the version of another deponent. This kind of supporting affidavit is called a confirming affidavit. The founding and supporting affidavits must cover all the elements of the area of law on which the applicant is relying, and must also contain all the evidence supporting these elements. Relevant documents, for example, copies of invoices, may also be attached to the affidavits as annexures. The equivalent provisions for the regional and district magistrates courts are contained in Rule 55, Subsection 1 of the Magistrates Courts rules. Once all the founding and supporting affidavits have been drafted, they must be attached to the notice of motion and sent to the sheriff for service. Number 4. Step 3. The service of the application papers. Number 4.1. Service in the High Court and District and Regional Magistrates Courts. Once you have drafted the notice of motion and affidavits and have had all the affidavits duly signed before a commissioner of oaths, you will deliver the original and at least 2 copies of the notice of motion and founding affidavits to the registrar or clerk of the court to be issued. That is, given a case number and date stamped. If there is more than one respondent, you will include an extra copy of the notice of motion and affidavits for each additional respondent. Once the application has been issued, a copy of the papers will be served on each respondent by the sheriff. Thereafter, the sheriff will file the original notice of motion and affidavits with the registrar of the court and deliver the remaining copy of the papers to you together with his return of service. Number 5. Step 4. Respondent's notice of intention to oppose. Once the application papers have been served on the respondent, the following will happen. Number 5.1. High Court Procedure. If the respondent intends to oppose the application, he must file a notice of opposition. This notice states that the respondent intends to oppose the application and sets out an address at which the respondent will accept the service of documents in the matter. In terms of High Court Rule 6, Subsection 5b, the respondent must be allowed at least 5 days after he receives the application papers to deliver his notice of opposition to the applicant. Because this time period is stipulated in the High Court rules, the days referred to are court days and must be calculated as such. If the notice of motion is served on the respondent at a place outside the jurisdiction of the division of issue, the respondent is allowed more than 5 days within which to deliver his or her notice of opposition. A period of 2 weeks is allowed if the place of service is less than 150 kilometers from the court, and 1 month is allowed if, in addition to being outside of the jurisdiction of the court of the division that issued the notice of motion, it is more than 150 kilometers from the court. Because of these 2 time periods are stipulated in the Superior Courts Act 10 of 2013, the days referred to are calendar days and must be calculated as such. In terms of High Court Rule 6, Subsection 13, if the application is against a minister, deputy minister, premier, officer, or servant of the state, in his capacity as such, the state or the administration of any province, then 15 court days must be allowed within which to deliver the notice of opposition. If you look at Form 2, Subsection A, you will see that the respondent is informed that if he does not deliver a notice of opposition, the application will be set down for hearing by the court on a stipulated day. In terms of High Court Rule 6, Subsection 5b, the date of the hearing may not be less than 10 court days after the service of the notice of motion on the applicant. Note that even though the notice of motion states a date for the hearing, you will nevertheless have to set the matter down for the hearing. You do this by delivering a notice of set down to the registrar. A copy should also be provided to your opponent. Number 5.2. Regional and District Magistrates Courts Procedure. If the respondent intends to oppose the application, he must file a notice of opposition in terms of Magistrates Courts Rule 55, Subsection 1g. This notice states that the respondent intends to oppose the application and sets out an address within 15 kilometers of the regional magistrates' courts, registrar or clerk of the court. In the case of the district magistrates' court, at which the respondent will accept service of documents in the matter. In terms of Magistrates Courts Rule 55, subsection G, 1 and 2, the respondent must deliver his notice of opposition to the applicant, and within 10 days of this notice deliver his answering affidavit. Because this time period is stipulated in the Magistrates Courts rules, the days referred to are court days and must be calculated as such. If the respondent fails to deliver a notice of opposition timeously, the applicant may place the matter on the roll for hearing by the court on a stipulated day, giving at least 5 days' notice in terms of Rule 55, Subsection 1f. Number 6. Step 5. The respondent's answering affidavits. If the respondent in a High Court matter delivers a notice of opposition in time, he must deliver his answering affidavit within 15 court days. That is 10 court days in regional and district magistrates' courts matters of the delivery of the notice of opposition. The answering affidavit should be supported insofar as may be necessary by other affidavits deposed to by witnesses who have direct knowledge of the events. In his answering affidavit, the respondent must deal paragraph by paragraph with the allegations and evidence contained in the applicant's affidavits, and state with which of the allegations he admits and which he denies. He must also set out his version of the relevant facts. Number 7. Step number 6. The applicant's replying affidavits. The applicant may deliver a replying affidavit within 10 days after the respondent's answering affidavit has been served upon him. In the replying affidavit, the applicant deals paragraph by paragraph insofar as may be necessary with the allegations and evidence set out in the respondent's answering affidavit. The purpose of the replying affidavit is to rebut any averments made in this answering affidavit. New matter may not be introduced at this stage, and the court will strike out any new matter contained in the replying affidavit, which should have been contained in the founding affidavit. Number 8. Step 7. Further affidavits. After receipt of the applicant's replying affidavit, further affidavits by either of the parties are permitted only at the discretion of the court. This means that an oral application will have to be made in court, requesting the court to authorize the filing of further affidavits. The reason generally for not permitting further affidavits is that the applicant is expected to set out the grounds and evidence for his claim fully in his founding affidavits, while the respondent is expected to set out the grounds and evidence for his defense fully in his answering affidavits. The applicant then has the opportunity to respond to anything new that has been raised in the respondent's answering affidavit by way of a replying affidavit. The court will therefore allow the filing of further affidavits only in exceptional circumstances, and will expect an explanation as to why the filing of further affidavits is necessary. Examples where the courts have held that special circumstances exist for justifying affidavits are: firstly, where a new matter or something unexpected has been raised in the replying affidavits. Secondly, where the courts instruct that further affidavits be filed. Third, where new evidence has come to the party's attention at a late stage. And lastly, generally, where there is the possibility of prejudice to the respondent if further affidavits are not allowed. Okay, number 9. Step 8. Setting the matter down for hearing. The application must be set down for hearing by the delivery of a notice of set down. The notice of set down instructs the registrar to place the matter on the court roll for hearing. In the case of opposed applications, the court will normally require the filing of heads of argument. Number 10. Step number 9. The hearing. The matter will come before the court on the date on which it has been set down. The court then has a number of options, depending on the contents of the papers. Number 10.1. The court's order if no real dispute of fact has arisen on the papers. If no real dispute of fact is apparent on the papers and the applicant's papers are in order, that is, they set out a valid cause of action supported by the evidence needed to prove the cause of action, the court will hear argument from both sides. If the court is of the view that a case has been made for the relief sought, the court will grant the order as prayed in the notice of motion. With Ex-Parte applications, the court may grant the order prayed if it is satisfied that the rights of no other person will be affected by the order, and that the papers are in order. If the order sought in an Ex-Parte application will affect the rights of third parties, the court will, at most, only be prepared to grant a rule nisi together with temporary relief. Number 10.2. The court's order if a real dispute of fact has arisen on the papers. If a real dispute of fact is apparent on the papers, the court may deal with the matter in one of four ways. Number 10.2.1. The court may decide the matter on the affidavits alone. Unless one of the parties requests the court to refer the matter for oral evidence or for trial, the court will usually deal with the matter on the basis of the undisputed facts. If the undisputed facts in the applicant's affidavits are not sufficient to persuade the court on a balance of probabilities that the applicant is entitled to the relief sought, the court will likely dismiss the application. Number 10.2.2. The court may refer the matter to oral evidence. Referral to oral evidence is usually done only where the disputed facts are restricted to a narrow range of issues. These issues may be referred for oral evidence. This will happen when one fact or only a few disputed facts cannot be decided on the affidavits, when the issues are comparatively simple and clearly defined, and when the evidence in question has a narrow scope. The matter will usually be placed on the expedited roll and will be heard sooner than trial brought in the usual course, depending on the caseload of the division. However, the court will not refer a matter to oral evidence when complicated issues are involved and it is not possible to know how wide a field of evidence the disputed issues will cover. The court will not usually exercise its discretion to dispute of fact was within the contemplation of the applicant when he instituted the application, and may, as a sign of its displeasure, dismiss the application with or without costs. When the court has doubts about the credibility of a deponent of an affidavit relied on in an application, it may order him to appear for cross-examination. Number 10.2.3. The court may refer the matter to trial. If the disputed facts cover a broad range of issues or are relatively complicated, the court will usually refer the matter to trial. In referring a matter to trial, the court may order that the founding affidavit should stand as the summons, and will give directions regarding the further exchange of pleadings. It will often treat the three sets of affidavits as pleadings, and if the answering and replying affidavits have not yet been exchanged, limit the normal time periods by instructing that the affidavits be served with only a day or so separating the exchanges. Alternatively, the court may define the issues to be decided at trial, and the matter will proceed to trial as if the pleadings were closed. In such a case, no further trial pleadings will be exchanged between the parties. The court often orders a referral to trial where the matter, although involving a dispute of fact that is wide-ranging in scope, has probably been brought by way of application, because of its urgency. For example, the referral of an application to trial is often the result in cases where urgent interdicts are brought ex parte. Number 10.2.4. The court may dismiss the matter with costs. If a real dispute of facts should have been foreseen by the applicant, the court may dismiss the application with costs. If the court dismisses the application because the plaintiff failed to make out his case, the order is equivalent to a final judgment in favor of the respondent. However, if the application is dismissed because of the existence of a factual dispute, the order does not operate as a final judgment. If the applicant's negligence is not clear-cut, the court will usually refer the matter to oral evidence or to trial. In the latter case, the court may still show its disapproval for the applicant's lack of diligence by awarding costs in favor of the respondent. Number 10.3. In certain cases, the court may decide to make no order. The court may decline to make any order on the application itself and give the applicant leave to renew the application on the same papers or postpone the application sine die. That is, without a return date with leave to file further affidavits. The court will usually indicate the shortcomings of the pending application so that the applicant knows what evidence to obtain to supplement the existing affidavits. The effect of this order, or rather the lack of an order, is that the applicant may bring the application again, but costs will normally be awarded to the respondent. Number 11. Step 10. Optional further steps, counter applications and joinder applications. High Court Rule 6, Subsection 7 and Magistrates Courts Rule 55, Subsection 2a require respondents to use the counterclaims procedure in actions as a guide when bringing a counter application, or when joining another party to the application. A counter application must be made if the respondent seeks relief beyond the mere dismissal of the applicant's application. Usually, the answering affidavit serves as the founding affidavit of the respondent's counterclaim, and the counterclaim's prayers may be included in this affidavit. The applicant's replying affidavit then has the dual function of serving as the replying affidavit in the application in convention and the answering affidavit in the application in reconvention. To prevent possible confusion, however, it is preferable to the respondent to file a separate notice of motion. Counter application provisions are not peremptory. C. Ex-Parte Applications. Number 1. Ex-Parte Applications in the High Court. Ex-Parte applications may be brought in the following circumstances. First, when the applicant is the only person interested in the relief claimed. For example, an application for admission as a sworn translator, that is, a person authorized by the court to translate legal documents from one language to another, as opposed to a court interpreter who does not need to be as highly qualified. Sworn translators are hired by attorneys or businesses for the translation of legal documents that will be recognized by the courts as being accurate unless proven otherwise. The sworn translator who brings the application has an interest in the relief claimed, but the only other party with an interest is the court itself. Secondly, when the relief sought is a preliminary step in the proceedings, for example, an application to sue by edictal citation, an application for substituted service, or an application to attach a person or property in order to found or confirm jurisdiction. All these applications simply prepare the way for the legal proceedings that are to follow, and cannot be said to take away the respondent's right to put forward his side of the story. Thirdly, when the nature of the relief sought is such that giving notice may defeat the purpose of the application. For example, an application to freeze someone's bank account. The purpose of this application is to prevent a person from dissipating the funds. Giving notice to the debtor of this impending application would simply encourage him to transfer the funds. Fourthly, when immediate relief is essential because the harm is imminent. For example, an urgent application for a temporary interdict. If, for example, you see that a ship which has an unpaid lien will be leaving the harbor at 4 o'clock or 1600 hours that day, you need to stop it almost immediately and arrest it in order for the South African courts to exercise jurisdiction over the ship. In those circumstances, you may proceed to courts to get an order without giving the ship owner and other interested parties notice. The urgency is such that you do not even have enough time to give the ship owner notice, let alone wait for the required notice period in terms of the rules before bringing your application. Fifth, where the application is usually brought ex parte in terms of established court practices. For example, applications for provisional sequestration and liquidation are brought ex parte in some divisions. Harms's civil procedure in the superior courts, however, expresses the view that these practices should not be followed unless special circumstances exist. And number 6, where the identity of the respondent is not readily ascertainable. For example, if the application may affect the interests of some or all the other all of the people living in a certain suburb, you cannot cite every single person living in the suburb in your papers. This kind of application has occasionally been brought to eject the occupants of informal settlements. But even here, where the respondents cannot be precisely identified, the courts will often insist that some kind of notice be given. Number 2. Ex-Parte applications in the regional and district magistrates' courts. Magistrates Courts Rule 55, Subsection 3 provides that ex-parte applications may be brought in regional and district magistrates' courts only where the following requirements are satisfied. First, the giving of notice would defeat the purpose of the application. Or secondly, the degree of urgency is so great that the dispensing of notice is justified. In addition, all ex-parte applications have to provide a specified return date on which cause must be shown why the order should not be confirmed, and a copy of the ex-parte order and supporting affidavits must be served on the respondent. Rule 55, subsection 3H, provides that ex-parte applications may be heard in chambers. Rule 55, subsection 5, deals with urgent applications and contains similar provisions to High Court Rule 6, subsection 12. There is no form corresponding with Form 1A for ex-parte applications, and it would appear that the same form with appropriate variations may be used in both cases. Number 3. Preparing ex-parte application papers. Number 3.1. High Court Notice of Motion. High Court Form 2 sets out the basic format for the notice of motion in an ex-parte application in the High Court. Form 2 requires the following information be included in the notice of motion. First, who the applicant is. Secondly, the date and time when the application will be made. Third, what order the court will be asked to make. Fourth, that the application is supported by an affidavit or affidavits attached to the notice of motion. And lastly, the name and address of the applicant's attorney. The form also contains an instruction to the registrar to set the matter down on the roll for hearing. In other words, a notice of set down is incorporated into the notice of motion. This automatic notice of set down is only possible in ex-parte applications. With an on-notice application, the date of hearing will depend upon whether or not the respondent opposes to the matter, and the notice of set down can only be delivered to him after that. Number 3.2. Regional and District Magistrates Courts. Notice of Motion. The Magistrates Courts rules do not prescribe a particular form for ex-parte applications in the Regional and District Magistrates Courts, and the format of High Court Rules Form 2 should be followed. Number 4. The Court's Options. Final Orders and Rules Nisi. In the High Court, where the court is satisfied that the rights of no other person will be affected by the ex parte relief the applicant is seeking, it will grant a final order, provided, of course, that the court is satisfied the applicant has made out a case on the papers. Sometimes, however, an ex parte application, in the opinion of the court, may affect the rights of the eventual respondent or other persons. In these cases, the court will not grant a final order, but will issue a rule nisi. In regional and district magistrates courts, however, the courts have no discretion. Rule 55, subsection 3c states that an ex parte order shall be of an interim nature. A rule nisi is peremptory. A rule nisi is a court order calling upon named respondents or other interested parties, a specified class of persons, or even the world at large, to give reasons, that is, to show cause on a date set by the court, why the order sought by the applicant should not be made a final order. Sometimes the applicant will need some form of relief before the return date. If this is the case, when the applicant asks the court to issue a rule nisi, he will also ask the court to order some form of temporary relief, for example, in the form of an interim interdict, which will take effect until the return date. Another way for the court to give temporary relief is to order that the final order sought by the applicant will have interim effect. This means that the order sought will operate against the respondent until the return date, on which day the court will decide whether to make it a final order. Note that in High Court, Regional and District Magistrates Courts, the respondent may anticipate the rule nisi return day to ask that the matter be dealt with before the return date of the rule nisi by giving not less than 24 hours notice. Number 5. Intervention in Ex-Parte Applications. In terms of Rule 6, Subsection 4b of the High Court rules, any person having an interest in an Ex-Parte application may apply to the court for permission to intervene in the application. This application to intervene must be in the form of a notice of motion requesting leave to intervene, and must be supported by an affidavit setting out his interest in the matter. Notice of the proposed intervention must also be given to the applicant, who may wish to file an affidavit opposing the proposed intervention. The Magistrates' Court's rules do not contain a similar provision, but Rule 55, subsection 1c, provides that notice of any application must be given to any person, not party to the proceedings, if it is necessary or proper to do so. Number 6. The requirement of utmost good faith in Ex-Parte applications. An applicant bringing an Ex-Parte application has a duty to be completely open and honest with the court, and has to reveal all facts that may be relevant to the matter, even those which may be detrimental to his case. Any breaches of this duty of utmost good faith could have extremely harmful consequences for the applicant's case, as the court may dismiss the application on this ground alone, irrespective of the general merits of the case. In deciding whether there has been a breach of duty of good faith, the court will take various factors into account, such as doing justice between the parties, the interest of innocent third parties, and the extent to which the court was influenced by the breach. Even where the breach of good faith has not been too serious, the court does not dismiss the application. The court may nevertheless make an adverse cost order against the applicant.